Welcome back, students. You're joining me for this explainer of Module 5, Lesson 1 of Evidence Law 1 by KMVTECH Education. Now, over the past 4 modules, you guys have built a really strong foundation. We've gone through the basics of evidence law, relevancy and admissibility, judicial notice, and estoppel. But today we're introducing a concept that is absolutely critical and highly practical: the burden of proof. Let me tell you, getting this wrong as an advocate literally means losing cases that you absolutely should have won. So we're going to take this slowly and clearly and really bring everything you've learned so far into sharp, practical focus. Grab your notebooks, let's get into it. Here's our roadmap for today's lesson. First, the Owino market theft. Second, defining the burden of proof. Third, legal versus evidential burdens. Fourth, the murder trial illustration. Fifth, the presumption of innocence. And finally, some discussion scenarios. Section 1, the Owino market theft. Okay, to ground this abstract academic theory in a real-world, high-stakes trial scenario, I want you to imagine we are standing right in the middle of the Kampala Chief Magistrate's Court. There are 3 key people in the room. Over on one side, you've got the prosecution lawyer. On the other side, the defense advocate. And sitting right there between them is the accused, a man who's been charged with stealing mobile phones from a really bustling shop down in Owino Market. The magistrate is seated at the bench, but hasn't heard a single word of evidence from anyone yet. It's completely quiet.
So at this precise moment, before anyone even opens their mouth, who actually must prove what? Well, the law dictates that the prosecution must prove that the accused stole those phones. The accused doesn't have to prove that he's innocent. He doesn't have to say a word, really. The magistrates simply cannot convict unless the prosecution completely discharges its burden. And that, students, is the burden of proof. Understanding exactly how this operates is, for sure, one of the most important skills you're going to develop as a legal professional here in Uganda.
Moving on to Section 2, defining the burden of proof. All right, here is the foundational definition you are going to rely on, so you'll want to take this down word for word. The burden of proof is the obligation placed on a party in legal proceedings to prove the facts necessary to establish their case. Basically, the party who bears this burden has to adduce enough evidence to satisfy the court on the matter in question. If they fail to do so, well, they lose on that specific issue. It's as simple as that. Statutorily speaking, you'll find this living in the Evidence Act, Chapter 8. We're looking primarily at Sections 101 through 113. Now, Section 101 establishes this really fascinating ironclad rule. Whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist. Put simply, if you assert it, you gotta prove it. And that brings us right to Section 102, which provides what is perhaps the single most useful test in all of evidence law. The Section 102 test asks a really simple hypothetical question. If both sides said absolutely nothing and called no evidence whatsoever, who would lose? The party who would fail if no evidence at all were given on either side, well, that is the party who bears the burden of proof. It's a brilliant, straightforward acid test for the courtroom, and honestly, you'd be surprised how many real-world cases completely fall apart just because lawyers forget to ask themselves this very basic hypothetical. Section 3, legal versus evidential burdens. Now, I need you to pay close attention here because confusing these next 2 concepts will absolutely cost you cases. First, we have the legal burden. You'll also hear this called the persuasive burden, or the burden of proof in the strict sense. This is the fixed obligation to prove a fact to the required standard of proof by the end of the case. The absolute most crucial point to remember is that this burden never, ever shifts during the proceedings. It remains fixed on the party who bears it from the very beginning all the way to the bitter end. Contrast that with the evidential burden, which is sometimes called the burden of adducing evidence. This is simply the obligation to raise sufficient evidence on a particular issue just to make it a live issue before the court. And unlike the legal burden we just talked about, the evidential burden absolutely can and does shift between parties during the proceedings. It's dynamic. Once a party raises enough evidence to make something a live question before the court, the evidential burden of responding might just shift right over to the other side. So to synthesize this for your notes, the legal burden determines who ultimately proves the case, and it remains completely fixed. The evidential burden, on the other hand, determines who must raise an issue at a particular point in time, and it can shift dynamically back and forth. Truly understanding this dual structure is the hallmark of a competent trial advocate. Let's move to Section 4, the murder trial illustration. Let's consider a murder trial before the High Court of Uganda. The legal burden lies squarely on the prosecution throughout the entire trial. The prosecution must prove 3 distinct things by the end of the case. 1, that the accused actually caused the death. 2, that the death was unlawful. And 3, that the accused had the requisite intent, also known as malice aforethought. This is their legal burden and never shifts. If they fail to prove even one of these elements to the required standard, the accused must be acquitted, period. Now let's look at how the evidential burden operates in that exact same trial. Suppose the accused raises a defensive alibi. They claim, hey, I was in Jinja at the time the murder took place in Kampala. By raising this and providing some evidence for it, they have shifted the evidential burden over to the prosecution to deal with it. The alibi is now a live issue in the trial. However, and this is vital, so write this down, the legal burden of disproving that alibi never shifts to the accused. The prosecution must disprove the alibi as part of their fixed legal burden to prove guilt beyond a reasonable doubt. To really see how these burdens interact at the close of a prosecution's case, we look to a landmark precedent. Please note the citation, Francis Xavier Kayemba versus Uganda, 1983. This case established what a prima facie case actually is. It's not just any random evidence. It is evidence on which a reasonable tribunal could convict if the defense offers no explanation. This Ugandan case perfectly illustrates how the legal and evidential burdens interact the moment the prosecution rests its case.
Section 5. The Presumption of Innocence.
You might be wondering, why does the legal burden sit so firmly on the prosecution in criminal matters? Well, the answer lies right in Article 28, Clause 3, Subclause A of the Constitution of Uganda 1995. It states crystal clearly, every person charged with a criminal offense shall be presumed innocent until proved guilty or until that person has pleaded guilty. This specific constitutional guarantee is exactly why the burden of proof functions the way it does. The accused begins the trial innocent, and they remain completely innocent until the prosecution actively discharges its burden.
To really capture the gravity of this, we look to one of the most famous quotes in common law history regarding this presumption. It comes from Viscount Sankey in the highly persuasive 1935 House of Lords case, Woolmington versus DPP. He stated, "Throughout the web of English criminal law, one golden thread is always to be seen. It is the duty of the prosecution to prove the prisoner's guilt. This golden thread principle isn't just history. It is cited regularly and with great academic gravity in Ugandan criminal courts to this very day."
Finally, Section 6, Discussion Scenarios.
Okay, so before your next class, I want you to evaluate 3 specific scenarios using the Section 102 test we discussed earlier. Scenario 1, a high court murder prosecution. Scenario 2, a civil claim for unpaid goods in a magistrate's court. And Scenario 3, an accused raising the defense of self-defense. For each of these distinct situations, I want you to carefully think through who bears the burden of proof.
In each of those 3 cases, ask yourselves, who would lose if absolutely no evidence were given at all? And furthermore, knowing what you now know about evidential versus legal burdens, how does that burden change and shift as each case develops in the courtroom? Hold on to those conclusions, write them out, and bring them to our next class discussion. Thank you for joining me for this explainer of Module 5, Lesson 1. Study hard, and I will see you next time.